I'm very grateful indeed to have been invited by Lawyers Hong Kong to speak to you today, and I commend this association on its initiative in arranging this legal forum, as well as on their very topical choice of theme. I'll be covering four main areas today, namely the 5 so-called demands of the protest movement, the prosecution of offenders, the sentencing of offenders, and I'll wrap it up with some thoughts of my own on the way forward. I hope I've got enough time to get through it all. I think I have, but if I'm encroaching on Cheng's time, he's very kindly said that I can have 5 minutes of his. But in any event, if that happens, then I'll accelerate my delivery. Now, as you all know, the rule of law is under huge challenge, not only from violence on the streets, but also from wanton destruction, and many people actually believe they are above the law and that they can defy it with impunity, which unfortunately they often can. Not only are people being attacked because they have different opinions or come from elsewhere, but some people consider they can destroy the businesses of others at will and damage public property. Following assaults at the universities on non-Hong Kong students and staff, many places have had to withdraw their people because their safety can no longer be guaranteed. Weapons factories have been created in various places, including universities, and petrol bombs have been produced on an almost industrial scale. Training has even been provided on campus into how to throw petrol bombs most effectively and how to harm police officers using bows and arrows and giant catapults. Indeed, when a police officer was hit in the leg by an arrow some days ago, it was reported that there was loud cheering from those within the Polytechnic University. Now, although the police force has tried its best to uphold law and order, it is obviously extremely stretched, if not exhausted. It's also had to curtail its regular foot patrols after it emerged that officers were being lured into traps online by people wishing to harm them. The police force has inevitably had to divert significant numbers of officers away from their regular duties in order to handle protest cases, and this is inevitably affecting regular policing. We know, for example, that there has, in the first 4 months of the disturbance, in comparisons with the same period last year, been an increase of thefts by snatching of 51%, of burglaries of 48.8%, of thefts from vehicles of 35%, and of robberies of 6.5%. So quite clearly the ordinary criminals are taking advantage of the redeployment of police to embark on a crime spree of their own, and this quite clearly also threatens the rule of law. Now, until recently, the judiciary appeared to be safe from the violence, although this is now changing. As you will recall, after an unsuccessful attempt was made by the Chinese University of Hong Kong Student Union to obtain an injunction in the High Court restricting police access to the university campus on November the 13th, there was an arson attack on the Sha Tin law courts, apparently in revenge for the judiciary's judgment. It seems, therefore, that the courts themselves are now regarded as fair game and that nobody is completely safe. And unfortunately, our judiciary is not only threatened from within. On November the 5th, the Foreign Affairs Committee of the United Kingdom's House of Commons called on the British government to review the arrangement whereby British judges, as well as judges from Australia, Canada and New Zealand, sit in the Hong Kong Court of Final Appeal. At present, for example, the President of the United Kingdom Supreme Court, Baroness Brenda Hale, as well as her 2 predecessors, Lords Newberger and Phillips, are non-permanent judges of the court. And the presence of these overseas judges, and others of course, has enriched Hong Kong's jurisprudence since 1997 and contributed to judgments of acclaimed quality, which are regularly cited in the courts of other jurisdictions. If the Foreign Affairs Committee was to get its way, Hong Kong would lose some very experienced judges and their expertise would undoubtedly be greatly missed. We must hope, therefore, that wiser counsels will prevail and that the Foreign Affairs Committee will not succeed in its attempts to undermine an arrangement which has proved so beneficial to the rule of law here in Hong Kong. Now, I'm sometimes asked if the levels of violence we have witnessed since June amount to terrorism, and the answer, I believe, is clear. In 2002, the United Nations Anti-Terrorism Measures Ordinance was enacted, and it describes a terrorist as, quote, a person who commits or attempts to commit a terrorist act or who participates in or facilitates the commission of a terrorist act. As for what constitutes a terrorist act, this involves the use or threat of action for the purposes of causing serious violence against a person, or causing serious damage to property, or endangering a person's life other than that of the person committing the action. The use or threat of action must, moreover, also be intended to compel the government or to intimidate the public or a section of the public, and be made for the purpose of advancing a political, religious, or ideological cause. Now, applying those criteria to the violence we've seen since June, terrorist activity is obvious. Police officers have been set on fire with petrol bombs, trains and stations have been torched, public and private property has been destroyed, public safety has been endangered, and people have been beaten up because of their views or where they come from. These actions, moreover, have regularly been committed by people with subversive or secessionist intents, as evidenced, for example, by their desecrations of the national flag, their brandishing of foreign flags, their slogans, "Hong Kong is not China," "Liberate Hong Kong," and "Revolution of our time," their destruction of copies of the Basic Law, and their attacks on the premises of the liaison office of the Central People's Government and the Xinhua news agency, as well as on mainland Chinese citizens. So these people clearly have political objectives which they want the central authorities as well as the local government here to accept. And they are pursuing these by the use of indiscriminate violence intended to intimidate and to coerce. And this falls within accepted notions of what terrorism means. And of course, the situation that we face is not helped by people, even lawyers, who fail to unequivocally condemn the violence and who actually blame the police for trying to maintain law and order. Nor is it helped by those people elsewhere who glorify the protest movement while disregarding its excesses. Such people, frankly, see Hong Kong as simply a pawn which they can use to try to undermine China. After all, China is now the chief geopolitical rival of the United States, and some people there, as well as in the European Union, are prepared to sacrifice Hong Kong's one country, two systems paradigm if this will further their objectives. This, of course, is why the US Congress has passed its Hong Kong Human Rights and Democracy Act, which is simply an exercise in mischief making, as also is the parallel bill to stop the sale of standard anti-riot equipment to the Hong Kong police force. These measures are not designed to advance a liberal agenda, but to encourage the protesters to carry on with their activities, thereby destabilizing Hong Kong and creating more problems for Beijing. And perhaps the most absurd exemplar of this strategy is Texas Senator Ted Cruz, upon whom President Donald Trump famously bestowed the moniker Lying Ted. In October, Cruz visited Hong Kong, as you will recall, all dressed up like a cowboy in black, and announced it was, quote, very much in America's interest to support freedom fighters in Hong Kong. But when asked about their violence, Cruz claimed to have seen none. But when he was pressed, he was reduced to claiming that perhaps Beijing's undercover agents were in fact responsible. Now, it's a great pity that he's not here now, as a visit to the courts would have shown him that the accused persons are all homegrown, many of them youngsters who have unfortunately been led astray by people like him. If they are convicted, their futures will be forever blighted, although it is they and not Cruz who will now have to bear the consequences. Let me now turn to the 5 demands themselves of the protest movement, none of which in my view is credible. At least one of the demands, that concerning amnesty, and I'll touch on this in a minute, represents a direct challenge to the rule of law and must therefore be rejected out of hand. Indeed, they are only proposed, these 5 demands, because the makers know that no government in its right mind could ever accede to them. And their intent, therefore, apart from humiliating the government, is to prevent dialogue and to have an excuse for continuing the mayhem and to strike at Beijing in that way. That these demands, originally drafted by laymen who knew no better, have now been endorsed by some lawyer politicians beggars belief, and shows either their extreme naivety, the deficiencies in their learning, or their desperation for votes. Let me now turn to the first demand, which of course was the withdrawal of the fugitive offender proposals, which has been acceded to, although its withdrawal has not helped the government. This, quite simply, as I warned at the time, is because, as we say in England, he who pays the Danegeld never gets rid of the Dane. Once the bill was shelved, the activists smelt blood, They saw that violence pays dividends and encouraged them to expand their demands. Although there is no need to dwell on this demand, it has to be said that the original proposal, which would have enabled Hong Kong to return fugitive offenders to the 177 jurisdictions around the world with which it has no extradition agreements, was a much-needed reform which would have enabled Hong Kong to discharge its criminal justice responsibilities at the international level. Instead, Hong Kong has become a criminal sanctuary in which fugitives from justice, some already convicted, from Macau, mainland and Taiwan can claim safe haven, along with an unknown number of fugitives believed to be substantial from other countries. This much-needed proposal was, of course, demonized by countries eager for an opportunity to poke China in the eye. The United States, for example, blasted the proposals and rolled out the red carpet for anyone from Hong Kong, including some legislators, who was prepared to go to Washington, D.C. to criticize them. This was notwithstanding that the United States had itself recently returned 3 criminal fugitives to China for trial, all without problem. The European Union also expressed its concerns, while the European Union Parliament condemned the proposals, even though 9 of its member states had already signed extradition treaties with China, under which, for example, Spain had recently returned 218 fugitives to Beijing in relation to a telecoms fraud. So this clearly was the height of hypocrisy, and once Chris Patten, a former governor, weighed in with an inflammatory video of his own designed to stoke alarms, many ordinary people here in Hong Kong were well and truly taken in and made fearful over a measure which in reality only criminals had cause to fear. Of course, the US, let alone Patten, never criticised Bulgaria, France, Italy or Spain for returning fugitive offenders to China for trial. They only singled out Hong Kong for wanting a similar mechanism. And this was presumably because, like bullies everywhere, they felt that Hong Kong was small and could not adequately defend itself. And in consequence, Hong Kong is now awash, not only with criminals responsible for the recent violence, but also with criminal fugitives on the run from justice in their home jurisdictions. This, I believe, is a significant fall from grace for a place which until quite recently prided itself on being amongst the most law-abiding in Asia, and which was once seen as a major player in the combat of transnational organised crime. Although Carrie Lam may have failed on this, at least she did try to ensure that criminals could not claim sanctuary here, and that they could be returned to face justice in an appropriate case to whichever of the 177 jurisdictions from which they were fleeing. Now, the second demand is for a commission of inquiry, a COI, not with an overall focus, but directed solely at what is called police brutality. It is therefore fundamentally skewed and designed to distract the police force from maintaining law and order. Although the police have been the victims of incessant armed attacks and have been repeatedly provoked, this demand seeks to place them, and not their aggressors, under scrutiny. It is a crafty ploy which has played well in some foreign capitals. And this, of course, I believe, is all part of a grand plan to weaken police morale at a crucial time. Other components of this strategy include endless complaints to the Complaints Against Police Office, designed to tie busy officers up in red tape, the attacks on police merit quarters, the doxing of police officers, the intimidation of the children of police officers at school, the disruption of police social events, and the injuring of off-duty policemen. Now, as Mr. Justice Henry Litton has explained, the causes of the unrest are manifold, and they include such things as the wealth gap, high rents, lack of affordable housing, and poor job prospects. For a commissioner to try to come up with cogent conclusions on all these issues would be well nigh impossible, and even if a report was ever possible, it would, given the massive potential evidence, take years to produce. There was no commission of inquiry after the 1967-68 riots, and now as then, it is for the Chief Executive in Council to review things and decide the way forward, and not to seek to evade responsibility by pushing everything off onto what Litton calls some hapless commissioner. In any event, I would have thought the causes of the civil disturbances can be simply stated. After a scare campaign was mounted by local politicians and China's rivals against a proposal to end Hong Kong's pariah status as a place which gives sanctuary to fugitive offenders, many people took fright without understanding the issues and started protesting. Many of those who protested were, moreover, unhappy about other things, often livelihood issues, and they saw this as a golden opportunity to vent their feelings. The peaceful protest movement was then hijacked by violent elements who could not frankly give a tinker's cuss about extradition and wanted to confront China by effectively declaring war on society. They had obviously been waiting their chance, and by using extreme violence, they hoped to provoke a reaction from Beijing and bring an end to one country, two systems, thereby damaging China's standing internationally. The central authorities, however, presumably realizing that a trap was being laid for them, have exercised great caution and declined to get directly involved, while offering every encouragement to the government here as it seeks to maintain law and order. So that, I suggest, ladies and gentlemen, is the long and short of it, and there is no need for a commission of inquiry costing millions of dollars, consuming thousands of man-hours, and taking years to reach conclusions, which in any event would leave many people dissatisfied. Turning now to the third demand, that the description of the riots, the protests as riots, should be changed. This, frankly, is the stuff of fantasy, worthy of Alice in Wonderland. Applying the duck test, if it looks like a duck, swims like a duck, and quacks like a duck, then it probably is a duck. And the organised violence used by protesters manifestly constitutes riot, as defined by the Public Order Ordinance, and the only live issue is the identity of the rioters themselves, and no more need be said on that. Now I turn to the fourth demand, that those responsible for criminal offences arising from the civil disturbances should be given an amnesty, with any charges withdrawn. Since some people have also suggested that pardons might be a possibility, I will also touch on that for the sake of completeness. Now, the term amnesty derives from the Greek word amnestia, meaning forgetfulness or oblivion. And an amnesty has been defined by the Black's Law Dictionary as a pardon by the government to a group or class of people, usually for a political offence. The act of a sovereign power officially forgiving certain classes of people who are subject to trial but have not yet been convicted. In other words, an amnesty has the effect of providing immunity from criminal prosecution for past offences. In 1660, for example, at the time of his restoration, England's King Charles II approved the Act of Indemnity and Oblivion, which granted amnesty to the followers of the country's former Lord Protector, Oliver Cromwell, but excluding 50 people, all complicit in the execution of his late father, King Charles I. In 1977, US President Jimmy Carter, in an effort to heal the nation's war wounds, granted an amnesty to thousands of draft evaders, albeit with some exceptions. He did this as the war, like the draft, was over. In 1986, President Ronald Reagan approved an amnesty for 3 million undocumented immigrants who otherwise faced prosecution for having entered the country illegally. The benefits of amnesty are said to include an avoidance of expensive prosecutions, an encouragement to lawbreakers to identify themselves, and the promotion of reconciliation. But an amnesty, however, affects fundamental rights. As the Constitutional Court of South Africa has recently explained, every person is entitled to protection from unlawful invasions of his or her rights to life, security of the person, and dignity, and when those rights are infringed, to be able to approach a court for relief. The granting of amnesty takes away this entitlement. And if an amnesty is granted, it means that the offender, of course, will not be punished for his or her crime, that he or she and others will not be deterred from again committing that crime or a similar crime, and that the victim of crime and his or her family will be denied the satisfaction of seeing justice done. Now, clearly, the graver the crime, the greater the caution the executive may be expected to exercise before considering an amnesty. Now, it's often said by proponents of an amnesty that what happened in 1977 provides a precedent. In 1977, as some of you will know, an amnesty was granted in effect to police officers in these circumstances. After the ICAC was established in 1974, it tried to investigate all types of corruption. This triggered concerns, particularly because in some areas, such as the enforcement of the anti-vice laws, corruption was an established way of life and was regarded as a necessary means of supplementing income. Within the police force, corruption was rife, and there was huge opposition to the ICAC's investigations of its officers, past and present. And this came to a head in 1977 when the ICAC's Hutchison House headquarters were attacked by off-duty police officers and its personnel were assaulted. A police mutiny was moreover threatened if the ICAC's investigations were not curtailed. Faced therefore with not only intimidation but also a collapse in law and order, the governor, Sir Murray Maclehose, had no choice but to tell the ICAC not to pursue many of its investigations, although an exception was made for what were called heinous crimes. So this episode, therefore, I believe, is not a precedent at all. Sir Murray Backhouse was not a free agent, and he was coerced in the most shocking circumstances. He did not, however, at least so far as is known, interfere with the corruption-related prosecutions being conducted by the legal department, and now the Department of Justice. In contrast, moreover, to the situation in 1977, which only concerned cases being investigated or likely to be investigated, many of the civil disturbance cases are now in the hands of the Department of Justice and are before the courts. In the event of amnesty, therefore, the Chief Executive would have to instruct the Secretary for Justice to terminate ongoing prosecutions, which would be unconstitutional. This is because, under Article 63 of the Basic Law, the Department of Justice controls criminal prosecutions free from any interference. And since Article 48(2) requires the Chief Executive to implement the Basic Law, any interference with the work of prosecutors, as people have suggested, would breach this provision, as well as Article 63 itself. Although the police force does not enjoy constitutional independence under the Basic Law, as the ICAC does and the Department of Justice does, it is nonetheless required under the Police Force Ordinance to preserve the public peace and to prevent and detect crimes and offences. So in the absence of any cogent legal or policy justifications, any attempt by the Chief Executive, either directly or indirectly through the Secretary for Security or the Commissioner of Police, to curtail police investigations into crimes would, I believe, offend its legal mandate. It is clear, therefore, that no basis exists for granting an amnesty to people arrested in connection with the ongoing civil disturbances. Very serious offences have been committed, and those responsible, I believe, must be held to account. Contrary to the impression which some people have given, the decision by Sir Murray Backhouse in 1977 provides no precedent for today. It was a dark day in Hong Kong's history, which saw brute force triumph over the rule of law, and that episode, hopefully, will never be repeated. Now, to grant an amnesty would obviously create outrage among the victims of crime themselves, if not the law-abiding public. Whether they be police officers who were stabbed or set on fire by petrol bombs, or civilians injured when they disagreed with protesters, or business owners whose shops and restaurants were destroyed because they had a different opinion or came from a different part of the country, the victims of crime would be fully entitled to challenge any amnesty given by the executive to those responsible by way of judicial review, and they would all have strong, if not unanswerable, cases. And indeed, any suggestion that the Chief Executive might instruct the Secretary for Justice to terminate ongoing cases would be unthinkable, not least on constitutional grounds. Although it is certainly true that under the Criminal Procedure Ordinance, the Secretary for Justice is not bound to prosecute a suspect if of the opinion that the interests of justice do not require interference, given the catalogue of very grave crimes that have occurred, the interests of justice manifestly dictate that those responsible should be prosecuted with the full rigour of the law. Now, I wish to turn to the associated question of pardons or commutations of sentence. By virtue of the Basic Laws 48, subsection 12, the Chief Executive is empowered to pardon persons convicted of criminal offences or commute their sentences. Now, the circumstances in which this is ever appropriate are strictly limited. They must have a legitimate foundation, particularly when the crime is grave. A sentence of imprisonment might, for example, be commuted to time served when a prisoner is dying or only has a short time to live as an act of mercy. In the United Kingdom, the royal prerogative of mercy dates back to the Norman Conquest and is now sometimes used to reward prisoners for exceptionally good conduct. In 1907, the British Home Secretary, Herbert Gladstone, told the House of Commons that numerous considerations influenced a decision to grant a pardon, including the motive, the degree of premeditation or deliberation, the amount of provocation, the state of mind, character and antecedents. But he added, however, that many other factors had to be considered in each case. And in the UK, pardons are, for example, occasionally given to prisoners who provide the authorities with valuable assistance, or who show great bravery while imprisoned, or who are deemed morally or technically innocent. Effect of a pardon. Does it wipe the slate clean? Now, in England's Act of Settlement of 1701, England changed the law so that a pardon could not stop an impeachment, I'm quoting now, where there is nothing to prevent the king from pardoning after the impeached person has been convicted and sentenced. And this reflects the current position both in the United Kingdom and in Hong Kong. Although a pardon indicates forgiveness, it does not remove a conviction. A pardon cannot overturn a conviction, as this is something that only the courts themselves can do. And if, of course, a conviction is flawed, the appeal courts would generally have set it aside well before the issue of pardon ever came up for consideration. And in 1984, in the United Kingdom's Queen's Bench Division, Lord Justice Tasker Watkins said that the effect of a pardon was to remove from the convicted person, quote, all pains, penalties, and punishments whatsoever that from the said conviction shall ensue, without eliminating the conviction itself. He added that the Court of Appeal was the only body which has statutory power to quash a conviction, and this is also true in Hong Kong. And this means, for example, that a job applicant or someone filling in a visa application must, when asked, disclose a previous conviction, although they may add that a pardon has been granted. And if, moreover, someone is convicted of another offence, the judge can take the pardoned offence into account in deciding on an appropriate punishment. And if a pardon is granted, it must be legally justified. The United Kingdom's former Justice Secretary, Kenneth Clarke, once said that the subject of the pardon must not be tainted with unclean hands. The grant of a pardon is therefore, like amnesty, judicially reviewable, even if it involves an element of policy, most obviously by the offender's victim. In these circumstances, therefore, there is no role for pardon or commutation of sentence, save in an exceptional case, perhaps involving assistance to the authorities, bravery, or ill health. And once people realise that a pardon does not expunge a conviction, much of its supposed attraction disappears. If people have been convicted of very serious crimes and received condign punishment from the courts, they must, whether they are young or old, expect to serve their sentences, whether of imprisonment or, in the case of youthful offenders, of detention in a detention, training or rehabilitation centre or a reform school. This ensures that they pay their debt to society and lets everyone know that actions have consequences and that nobody is above the law. But that apart, to start handing out pardons or commutations of sentence to people who have been convicted of serious offences arising from civil disturbances after long trials would also be a waste of time and money. There would also, unless every single such offender were to be pardoned or given a commuted sentence, be practical difficulties. If only some offenders were to be selected, the whole process could well get bogged down in claims of arbitrariness, with some people complaining they had not also benefited from executive clemency. If, moreover, those convicted of political violence, perhaps young offenders, were to be pardoned or commuted, it would inevitably cause other young offenders convicted of generalised violence or other serious crimes to feel aggrieved, and their grievances would be legitimate. After all, political violence is no less reprehensible than other types of violence, and may actually be graver, as where it involves terrorist-type activity, such as manufacturing petrol bombs, which some 15-year-olds were reportedly doing during the occupation of the Chinese University of Hong Kong. Again, as with amnesty, the victims of crime would feel cheated of justice if the culprits were pardoned or had their sentences commuted for no good reason. Now let me turn to the fifth demand, universal suffrage. This, of course, is something contemplated by the Basic Law, but by their actions, some people here have managed to blow it for Hong Kong. For China, the one country, two systems paradigm was very much an experiment, and a bold one at that. This is why, for example, Hong Kong's Basic Law provides for universal suffrage for the Legislative Council, whereas Macau's Basic Law does not. If the Hong Kong experiment had succeeded, it could not only have ensured that one country, two systems endures beyond 2047 with a functional democracy, but it might even have provided a model which could be adapted for use in other major Chinese cities. However, so far that opportunity has been squandered. Some democratically elected legislators have not only used their positions to promote hostility towards their own sovereign China at each and every opportunity, but have also colluded with their country's geopolitical rivals and gone to foreign capitals to urge their leaders to confront Beijing and even to enact legislation which targets Hong Kong. They have encouraged criminal fugitives from elsewhere in China to come to Hong Kong and escape justice. The same people have also made a mockery of legislative affairs, whether by turning the oath-taking ceremony into a farce, by disrupting parliamentary business, or resorting to violence in the chamber itself. The quality of these politicians, quite clearly, is extremely low, with, for example, even the lawyers amongst them acting as apologists for rioters, or misleading the public into thinking that an amnesty for criminals is legally permissible, or trying to make their points by juvenile chanting on camera. Seeing such irresponsibility, it should surprise nobody if Beijing is unconvinced of the value of further democratic change, at least at this time. In 2014, moreover, the NPC Standing Committee agreed a formula whereby the chief executive could, for the first time, be elected by popular vote. But this, of course, was rejected by the Legislative Council, as some people said it was too restrictive. Rome, of course, was not built in a day, and had this tentative first step been adopted, it could have paved the way for greater democracy. I will mention this again in my conclusion, but when people call for more democracy now, it is little wonder that Beijing, having been rebuffed in 2015, is unimpressed. After all, once bitten, twice shy. And anyone, moreover, who thinks that modern China can be swayed into agreeing to anything by street violence has no understanding of history. So much for the 5 demands. Let me turn now. I'm still all right for time?
Well, almost there. But,
Can I have another 5 minutes of yours? 10 minutes. He's given me 10 minutes. But I'll increase my pace as well. Now, prosecuting offenders, there have been approximately 4,500 arrests, and the day of reckoning is fast approaching for those who've been participating in the violence. And once the police investigations are complete, the only issue will be a question of identification. And the Department of Justice's public order events team, known as POET, will need to decide if there's a reasonable prospect of conviction and what charges are most appropriate. The Department's Prosecutions Division is under huge pressure, and the Secretary for Justice must ensure that this team is fully manned and adequately resourced. If necessary, the Secretary may have to consider retaining a cadre of experienced barristers to support the POET, perhaps as many as 20, either in advising on the cases or in prosecuting them, or both, and answering to the DPP. The sooner the cases can be brought to court, the better, as it is only then that the courts will be able to mete out appropriate sentences. In particular, there must be no repetition of the huge delays in processing cases which arose after Occupy Central in 2014. Given the high levels of violence used by the rioters and the threats to life and limb, the public interest requires that the suspects are prosecuted on the most serious charges available. If, for example, the evidence shows that someone set police officers on fire by throwing Molotov cocktails, attempted murder charges will be appropriate, in addition to the explosives charges. Prosecutors should also maximise the number of charges, thereby ensuring that the courts can adequately sentence. If, for example, someone has desecrated a national flag which was taken unlawfully from a public building, the desecration charge can be supplemented by a charge of theft or handling stolen goods, as the case may be. And anyone who aided and abetted any of the violent crimes by providing advice, equipment or finance can also be charged with the substantive offence, and prosecutors must ensure that they, as well as the frontline offenders, are held to account. There is, moreover, as I said earlier, a concerted campaign underway to smear dedicated police officers, and this is why many complaints are being lodged with the complaints against police officers. Many of these will be found to be false complaints, and those the makers must therefore be prosecuted for that offence, and also, if possible, for attempting to pervert the course of justice by trying to destroy the careers of professional officers. Because the time is running out, I'll say very little about sentencing offenders and leave that to Cheng, and I'll go straight to my conclusions. Now, there is certainly no magic wand that can be waved to solve the civil disturbances, although I do have some thoughts on the way forward. First, everyone involved in the protest movement, and particularly the young, must be made to understand that violence will get them nowhere. Violence is the sworn enemy of the rule of law, and to this end the legal system must ensure that culprits are investigated, prosecuted and tried, and that severe sentences are imposed upon the guilty. Second, the government must make no further concessions to violence, but must resist it with all the means at its disposal. One concession has already been made, but this simply encouraged the protest movement to demand more, so let lessons be learned. Third, the government must not only support the police force, but ensure that it has the necessary manpower, the latest equipment, and full resources. Hate forums, which provide discussions of how to attack police officers, how to escape once injuries have been inflicted, and how to make bombs, must, where possible, be shut down. Any attempts to undermine police morale, however they are dressed up, whether as investigatory commissions or otherwise, must be given short shrift. Fourth, the protest movement must be left under no illusions over independence and self-determination, neither of which will ever happen. Anyone who knows China's history should be able to understand that the country will never again allow itself to be divided up, as happened in the 19th century. And only once this is fully appreciated can there be any progress on political reform. Once China's leaders can be assured that Hong Kong is not being used by violent protesters to challenge national security and territorial integrity, it should, I believe, be possible to move forward in other areas. Fifth, the protest movement must appreciate that Hong Kong's future lies with China, and that if its leaders continue to collude with foreign powers, this will not only get them nowhere, but it will be counterproductive. If they want to talk to anyone, they should concentrate upon the leaders of their own country, whom they may well find to be more responsive than they imagine. Sixth, it has been heartbreaking to see children under 16 involved in bomb-making, criminal damage, and crimes associated with violent protests. One wonders how they could have been led so badly astray and who is responsible. Quite clearly, there is a failure here of both parenting and schools, although peer pressure, fake news, and cheap thrills will also have played their part. The Education Bureau must therefore get a grip on the situation and ensure that children in future understand civic responsibility, moral values, and national history, as well as China's developing role in the 21st century. After all, although Hong Kong has its own distinct system, it is an integral part of China, not an extension of the United Kingdom or the United States, and this must be fully understood. Seventh, since so many young people know all about their rights but nothing about their responsibilities, those entrusted with their education must start explaining what society expects of them. It is no good blaming the government if the teachers are not delivering the right message, and they must now step up to the plate. They must explain that the only reason that Hong Kong is able to retain its capitalist system and way of life unchanged for 50 years is because of the basic law and national law of China. In return, Hong Kong has responsibilities to the rest of the country, most obviously in the areas of national security and law enforcement, and these must be discharged, particularly if Hong Kong is going to retain its privileged status in the year ahead. Eighth, I'm nearly there. Eighth, the government must now decide how best to implement an effective national security law as the basic law mandates. Although Hong Kong's existing laws cover treason, sedition, and theft of state secrets, there remain, after 22 years, a vacuum in respect of secession and subversion, which can no longer be countenanced, particularly in light of recent events. These offences must be prosecutable here, and inaction is not really an option. After all, Macau, as required by its own basic law, implemented its national security law within 10 years of its reunification, and the heavens have not fallen in. Ninth, the government must, while hoping that the Hong Kong special trade status with the US will continue, now prepare for the worst. Following Congress's hostile legislation last week, we have to accept that there is a real chance that as China's global role expands, the US will become increasingly desperate and will retaliate by hitting Hong Kong, which it will then treat as collateral damage. This, therefore, requires the government to consider the effect of losing its current status and to prepare alternative arrangements to cushion the impact, including the expansion of existing markets and the development of new trading opportunities, most notably under One Belt, One Road. Tenth, and finally, the government must continue to focus on livelihood issues, to address the wealth gap, to develop affordable housing, and to ensure that its people are able to take full advantage of the huge opportunities which are now opening up as a result of the closer integration of the Guangdong, Hong Kong, Macau, Greater Bay Area. Once Hong Kong turns its back on the hatred, negativity and violence to which it has fallen prey and accepts its responsibilities and embraces its opportunities, I have no doubt that it will be able to reclaim its role as a unique city with real influence not only in China but also internationally. Thank you very much indeed.
More about just make sure I don't make use of my less than 15 minutes that I have. Thank you, Basil, and thank you very much, Grenville, for a very robust speech. Perhaps my speech will tend to be perhaps hopefully less controversial. It's about the arrest, investigation, and trial of an arrested person. The criminal justice system in Hong Kong is facing unprecedented challenges. I don't think in the history of Hong Kong, the rule of law, especially, can you hear me at the back? Sorry, I'll start again. The criminal justice system in Hong Kong is facing unprecedented challenges. I don't think in the history of Hong Kong, the rule of law, especially in criminal cases, has ever come under such great strain. And at the forefront of the criminal justice system is the police officer. The police officers remain the only guardian of peace and order in our community. They are our guards against the breakdown of law and order. From the moment the police officer decides to arrest someone until the trial of a defendant, there are so many pitfalls and hurdles to overcome before conviction can be secured. We now know there are about 5,000 persons, supposedly protesters, have been arrested since June. Many have been charged, many on bail for further investigation and or legal advice. The arrested 5,000 persons, they compared them with the number arrested in 1967, at the time of the riots. At that time, 4,498 persons were arrested, and there were 2,077 convictions in 1967. But then, in 1967, the population of Hong Kong was 3.87 million, and today is 8.7 million. So those are the comparisons. The arrest. Under the Police Force Ordinance, Chapter 230, effectively, every police officer shall be deemed to be always on duty. So they have to make arrests in the circumstances deemed necessary. Now, in these messy times, police resources are obviously very overstretched. A police officer has to make quite often a very quick decision whether to arrest someone. A determined protester, as we all know, is likely to be well camouflaged and potentially violent. Once an arrest is made by the police officer involved, he will ensure the arrested person is passed down a chain of custody, which sooner or later has been recorded in a number of documents, all which must stand up to the scrutiny of a court of law. So please have some pity on the average police officer. There's also the Police General Orders, and those available to the public alone contain some 76 chapters. And the police officer must, so far as possible, follow these rules and regulations when they arrest someone. Such menial, and I mean paperwork, but important tasks are, you expect, very time-consuming. Yet they are absolutely indispensable in a society like ours based on the concept of rule of law. Now, such menial works includes the following. The arrested person has to be taken to a duty officer. Particulars of the arrested person has to be entered into the Communal Information System, CIS. Capital complaints have to be dealt with separately. Search and handling of properties have to be recorded properly. More documentary work if arrested person has been transferred to another police station. On top of it all, the police officer responds properly to requests from members of the public or relatives. More documentary work involving fingerprintings and photographs and searching previous convictions. Arranging formal ID parades if necessary, and where to detain arrested person. So can you imagine the average person? It's easy to make an arrest, but the procedures can be very time-consuming and complex. In Hong Kong, also, of course, remember, an arrested person can only be detained for up to 48 hours, compared with England, up to 96 hours, and in England, under the Terrorism Act, up to 14 days. So it was in Hong Kong, the average police officer has a maximum of 48 hours. The evidence. But But making an arrest is easy compared to the much more difficult job of presenting cogent evidence as to what the arrested person has actually done before a court of law. The police, of course, have many sources of potential evidence. I think nowadays one of the most important is television, CCTV footages. Seized mobile phones may contain the most cogent evidence. Photographs, WhatsApp, Telegram, and other similar messaging apps like WeChat. Ironically, in these days of social media, as used by the protesters, it is those very apps that may result in the convictions. Because those apps will show their movements, what they've been doing, they've been messaging each other and suggesting where to go, but of course, the police officer must be able to seize their mobile phone. And of course, one of the most important aspects is the evidence given by the arresting officer himself or herself, but perhaps, and understandably so, in the confusion, chaos, and mayhem of a riot, the oral evidence of police officer may well carry less weight than what was video or photo recorded and can be shown to the court. Now, some defendants, especially determined and well-versed rioters, may well come up with many different accounts of what he or she was doing. The classic defense, of course, being I was acting in self-defense, the police attacked me, or was merely trying to calm things down, or was trying to prevent the police from being attacked. So those are quite often the defenses put forward. So in these confusing times, the courts will have to rely more on untainted independent evidence, such as videos, photos, television, and the contents of mobile phone. But in the occupied center cases, most convictions, I understand, rested on such untainted independent evidence. The question of identification. When it comes to evidence, one of the most difficult areas is identification. Did the police arrest the wrong person, or did the police wrongly identify the person who allegedly committed a particular criminal offense? Quite often, because of the confusion and sheer number of protesters in one particular spot, a wrong identification can easily and inadvertently be made by any police officer. And of course, it could well be the case, again more often than not, that the subsequent formal identification period will be quite meaningless. Hence, the more important task for a police officer is to ensure the correct custody of an arrested person until the moment the arrested person is charged and the police officer has completed the documentation of the person's identity. There are indeed lots of official documents and forms to be completed, all very time-consuming and tiring, especially after a hard day's work on the front line in the face of violence. When it comes to the trial, there's simply not enough courts and magistrates to deal with so many potential cases. You must have heard recently of magistrates having to sit past midnight to dispose of cases involving protesters. Recently, a record number of 200 persons were arrested and charged in connection with the protests outside the Polytechnic University. 6 courts across Hong Kong has to dispose of these cases beyond midnight. But it's simply the tip of the iceberg. Only, I believe, 20% of the iceberg is visible. Next question, when would the actual trials take place? Justice delayed is justice denied. Memories fade. Next question, the police can decide whether to prosecute, but more serious cases need legal department advice. And in some cases, the consent of a senior law officer is mandatory in some offenses. For example, recently, 5 defendants had to be released and rearrested because of some spelling errors in the consent to prosecute documents. And then more legal advice means more counsel need to be appointed. More magistrates have to be appointed. More district court judges have to be appointed because, as you appreciate, district court judges can only impose up to 7 years. There are many violent protesters who deserve more than 7 years. There have been talks in recent years, but never came to fruition, that there should be amendments to the district court ordinance to increase, for example, district court, the power of district court judges from 7 years to 10 years, because then it will lessen the strain on the on the jury system, because the next step will be the jury trial. Trial by jury, again, is a very, very important area, because whilst the director of prosecution has discretion over the venue of a trial, in most cases, in very serious cases, such as, for example, attempted murder, he has no such discretion. And because the maximum sentence in a high court is life imprisonment. And of course, trial by jury is a right now enshrined in Article 86 of the Basic Law. But in fact, very few jurisdictions under British rule have retained jury trials. Malaysia, Myanmar, India, Sri Lanka have all abolished jury trials. The late and much respected Cambridge-trained lawyer and Prime Minister of Singapore, Lee Kuan Yew, famously abolished jury trial in the island state in 1969, soon after independence. He was a very distinguished barrister and successfully represented many defendants, even those charged with capital murder. In his memoirs, he explained why he did not hesitate to abolish the jury system. In successfully defending 4 Muslims for murder, Lee confessed he worked on the weaknesses of the jury, their biases, their prejudices, and hence he succeeded in getting 4 persons acquitted of murder. He found the jury system to be a foolish system and too alien to Asian culture. And he said, I have no faith in a system that allowed the superstition, ignorance, biases, and prejudices of 7 jurymen to determine guilt or innocence. Interestingly, another well-known English criminal lawyer, Queen's Counsel, the late Louis Bloom Cooper, advocated a dilution of the right to jury trial, even in England, especially in complex commercial cases. Now, the crucial point I'd like to make is that jury need not, and indeed cannot be compelled to give reasons for their verdicts. Now, whether this will continue to serve the jury system well, especially in cases involving violent protesters in Hong Kong, remains to be seen. It's a matter worth pondering about, because in very serious cases, if the violent protesters, criminals go, or defendants go to the High Court, how would the jury system help us? Would it be an impediment to justice or be conducive to justice? That question remains to be seen. Now, I think I have effectively, hopefully, very quickly finished my short speech. I'd like to add a few words perhaps, because I think perhaps it might be important for you to ask questions and for me to answer them if possible. I've got a little bit of contribution to make to the question of amnesty and pardon. Because I think essentially on the question of amnesty and pardons, they are essentially political decisions. They are not, in a sense, legal decisions. They're part of the legal process, but essentially they are political decisions. So they have no part to play. Now, as I understand it, amnesty, as Grenville said, in relation to the ICAC matters, and amnesty is normally given before trial or before conviction, whereas pardons are given after conviction. Now, I think amnesty is hardly ever given, perhaps in cases like maybe in revolutions, like maybe there's one system being overthrown by violence, another system takes over, then a new system, a new government might grant amnesty to the people who have fought for the particular freedom or over change of regime. But normally, when crimes involve violent crimes, amnesty are never granted, especially except perhaps in some religious countries like Thailand or in some coronation, some special occasion, like coronation of a king or queen in some places in Asia. I heard about those cases. But pardons can only be considered after trial and conviction. Pardons has no part to play until all the legal remedies have been exhausted. then only later become a political act by the executive, by the partners of law. Anyway, those are the matters I'd like to talk about. I'm not going to all the 5 demands mentioned by Grenville, except to say that I share most of his views, especially on the commission inquiry, which I think is absolutely futile, because Hong Kong is facing political problems, and no allegedly independent judge can solve political problems on his own. It's absurd. Thank you very much.
Hello.
I'll leave most of the answers to Grenville.
So if anyone has any questions, please could you write them down on the pieces of paper that have either been passed out or will be passed out at your request, and write them down and pass them to the our staff in the middle in the aisle. In the meantime, I have some questions for the both of you. Thank you for the very engaging talks just now. And can we talk a little bit about this, one of the 5 demands, which is the Commission of Inquiry. That's been made, a lot has been made out of it. And even lawyers and ordinary folk, okay, who see themselves as fairly neutral and not taking sides in this political issue, don't understand why, first of all, the CAPO, the Complaints Against Police Office, or the other sort of police organs that are in charge of investigating complaints, they don't trust that those bodies are sufficiently independent. They are constituted, within the police framework to investigate the police themselves. On what basis can we say that those bodies are independent, and and the secondary question really is also, surely in the heat of the moment, and the excitement, and the stress of the job, there must be occasions where the police have overstepped what would constitute appropriate or reasonable force. Okay, why haven't those been brought to light, and why haven't those been investigated as of yet?
Well, I think CAPO, perhaps in many aspects, is not a very satisfactory organization. I think many people think it's perhaps not sufficiently strong enough. It doesn't have the right, for example, to subpoena witnesses and things like that. I do understand that. But the answer is not the setting up of a commission of inquiry. I think it's easy to set up a commission of inquiry, but there's so many endless problems associated with setting up inquiry. First of all, to the point, a so-called independent judge. Now, the first question is a judge necessarily a superhuman being? He must have his own prejudices, he must have his own thinking, he must have his own philosophy, political outlook. He may suppress them, but they're all there. The second thing is, perhaps more importantly, what are the possible terms of reference? I mean, I wrote an article about that, for example, like, what are the terms of reference? I mean, and who are the representative protesters? When the government can set up and say these are the terms of references, but then the protesters will say we disagree. So who will decide what the terms of reference? I mean, the commission inquiry may not even have a good start. There might be disagreement, even from the very beginning. And I want to go into endless problems. Perhaps even more importantly, how long will such a commission take to come to a finding? Can you have a time constraint? Who are the witnesses to call? Do you call the police to give evidence? Do you subpoena the commissioner of police to give evidence? Do you ask for the revelation of confidential documents, how the police acted? For technical reasons, why they go to South Shui-Po instead of Mongkok? I don't know, endless problems involved. And then ultimately, who are to represent, how many protesters are going to give evidence? 100 protesters, 200 protesters? Who are going to give evidence for the government? So the endless I think calamities involved in this, and ultimately, Hong Kong has many political problems that cannot be resolved by a judge. A judge is not superhuman being. Political problems are to be solved by politicians. That's my answer.
Thank you very much, Cheng.
Just following on from Cheng's point, that of course was exactly the conclusion that was reached after the 1967-1968 riots. That it wasn't a question of a commission of inquiry, it was a question for the then governor to review what had happened and to decide on the way forward. But looking at the complaints against police office, I used to be the legal advisor to the capo in the 1980s, and at that stage there was not much by way of oversight. But of course, in more recent times, the IPCC has been created, which is currently chaired by Anthony Neo and various other independent characters. And of course, they go through the results of each and every investigation, which is conducted by Capo, and keep Capo on its toes. And if they're not happy with the conclusions which are being reached, or if they see that a particular area of investigation hasn't been followed up on, then they will tell them to go away and check it all out. So this is a huge improvement, and I think that realistically most people have to have confidence in people like Tony Neo and his team to come up with the right answers. And of course, in terms of the current inquiry which he's doing, he has called in the assistance of outside experts, and I think we must wait and see what their report ultimately says. But as I said in my remarks, and I agree with Cheng, that a commission of inquiry would many people think, we better try and find a solution to these problems. Let's set up a commission of inquiry that might provide us with a way out. But the logistics of it would be horrendous. As Cheng says, it would be incredibly difficult to draw up any terms of reference. Problems are still ongoing. There'd be hundreds of witnesses required. Batteries, teams of lawyers would have to be retained to represent the different parties. And realistically, any report, assuming it was possible to come up with conclusions, would be years down the line. And what we need now is something in the fairly near future. So I think people are sort of grabbing at straws by saying that let's start a commission of inquiry to get to the bottom of it all. But also, as I made the point in my remarks, that the demand which the protesters have, not only the protesters, but their apologists and their supporters in the political world, it's not just for a political inquiry, it's for one which is focused on police brutality. That's what they want, and that is the giveaway, because it shows that this is not an inquiry that they want to look at the whole thing holistically. They simply want to use the commission of inquiry as a means of undermining the police force and its morale at a critical time, which is why it must be resisted.
Can I just add one message? Because it seems the police are against such an inquiry. If the police are against it and we set such an inquiry, what happens if they go on strike or work the rule? I mean, it's possible. Then what will happen? The complete breakdown of law and order.
Thank you very much for those answers. The Law Society of Hong Kong has actually come up with a proposal for a more general inquiry into the roots of the protest and sort of the underlying problems around the protest, and I guess some of that would maybe touch on the police, some of that on the protesters. I'm not sure. Yeah, I'm sure they're going to be facing some of the problems that you mentioned in terms of reference and so forth as well. So that's just something on Law Society. Okay. Thank you. So I want to touch on something that Grenville, you mentioned earlier about terrorism. I think as Lawyers Hong Kong, we've recently also put out some information on what constitutes terrorism under the UNATMO, and what we've said corresponds to what you said earlier. But I want to throw this question out to the both of you. Assuming that the sort of protest violence falls under the definition of terrorism, what can the government use that for? What can the government do with that usefully to try and curtail the violence?
Well, I suppose, they have to use those emergency regulations, haven't they? Unless they're able to pass new legislation, you have to fall back on the old ones. I know it declared unconstitutional for the time being, but this modest law on the mass law has been declared unconstitutional. So it's a difficult task. I mean, it's very difficult for the government to introduce more emergency regulations. But in the absence of any legislation from LawyersHK, what else can you fall back upon? I mean, locally speaking, unless under other article it is on the basic law, China can declare Hong Kong to be in turmoil, and then national law will apply. But short of that, we have to find a solution ourselves. And subject to what Grenville said, I can't think of any other emergency regulation you can introduce other than under the emergency regulation ordinance.
Well, we are actually quite fortunate so far as the criminal law covers most types of activity that we've been seeing. Obviously, someone who throws a bomb and tries to kill a police officer, that's attempted murder. Someone who puts objects on the railway line hoping to derail the train, there's a specific offence in that area. But as I mentioned in my remarks, I think it's important to reflect the gravity of what is going on, that prosecutors use their imaginations and try and lay as many charges as possible in order to give the courts at the end of the day the maximum powers to impose severe sentences. I gave the example of desecration of the national flag. You may recall that recently some people got very upset when a community service order was given to someone who'd desecrated the flag. And that would have been an area where perhaps, given that the flag had been stolen, a charge of handling stolen goods could have been added as well, which could have significantly enhanced the sentence. So by and large, the criminal law can cope with most of the types of crimes which have been arising, and prosecutors have to be quite imaginative in the way in which they go about their tasks of identifying the appropriate offences.
Thank you. On the subject of obviously the judgments that have been handed down by the courts have been a subject of some controversy, and actually the subject of some of these questions we've received from the audience. So on that subject, why don't I go on to ask? There's a question here of why bail has been set at such low amounts as to be deemed ridiculous, such as under $1,000 even for someone who was set on fire in front of a crowd, and so forth. So what what's what goes? What's the is this a matter of the magistrates' sort of individual inclinations?
I don't think one can interfere with the independence of the magistrate. He or she has a judicial discretion, and unless the prosecution asks for a high amount of bail or opposes bail, it's very difficult for any magistrate to refuse bail. And after all, bail is a question of right nowadays under the criminal proceeding ordinance, unless it's now for the prosecution, for many years now, and for the prosecution to give reasons why bail should not be given. So bail is a question of right. And I mean, I've spoken to a number of magistrates, and I asked them, and I said, why is it, almost inevitably bail is granted? You say, almost inevitably, prosecutions don't object to bail. So I think, to be fair, partly because the number of arrested persons, it may take a long time for them to decide, to collect the evidence, and then to decide, ask for legal advice, venue or trial. So normally in the past it may take 6 weeks, now it may take 3 months. So therefore, understandably so, in many of those cases, they do not object to bail. But again, it's a matter, perhaps ask the DPP, who might be in a better position to answer that question.
But of course, one of the concerns has always been that it takes so long for these cases to come on for trial, and often there's a lot of preparation that needs to be done. Obviously there's a presumption of innocence, and if at the end of the day the person is acquitted, then obviously it's unfair that he or she, unless it was absolutely necessary, should have spent, for example, 12 months or 18 months or 2 years in custody awaiting the outcome of the trial. As Cheng says, there is a presumption of bail built into the criminal procedure ordinance, and people are normally entitled to bail unless there's a chance that the person will flee, unless there's a chance that the person will interfere with witnesses. And what's the third one? The three criteria for bail: interference with witnesses, absconding, and committing another offence. So those are the normal three. Obviously, and in addition to that, of course, it's open to the prosecution to ask that particular terms be imposed. I mean, prosecution could say we feel that the travel documents should be surrendered, or that there should be curfew. The person should have to report regularly to the police station. All these types of conditions can be built in, and I think it's important they are built in, because we have seen cases of people absconding. Of course, earlier this year we saw 2 offenders absconded and then sought asylum in Germany. So there are clear dangers of people not turning up for trial. These have to be borne in mind, I would have thought, by the magistrates.
Thanks again. Again, on the court's decisions, something that's been quite topical recently was the court's decision that the anti-mask regulation was unconstitutional. What are your thoughts on that?
I think Grenville and I discussed about this very question. I mean, perhaps you answer it first.
Well, as far as I know, the suggestion that there should be an interpretation wasn't raised before the divisional court when it considered the matter. It may be argued more fully when it gets to the Court of Final Appeal if it goes that far. But on one view, it is possible to argue, I suppose, that this case meets the criteria for an interpretation in the sense that under 158, the courts are required to seek an interpretation where the interests of Hong Kong and the mainland are engaged, the relationship between the two places. And if one takes the view that what is going on here is in effect an insurgency, not only against the local government, but also more widely against the central government in the sense of subversion, then it could be said that the mask law, as one of the measures which is required to maintain law and order in Hong Kong, is something which also affects the interests of the mainland. And if it be right, then there's certainly an argument that this is in the area of interpretation.
In fact, one or two areas of my concern, two judges decide this case. I mean, I would have thought 1 or 3 judges would be better than 2 judges. What happened if one disagree and one agree? I don't know about it. And then the other thing that worried me a bit is, I'm not sure it's possible in judicial review. I haven't done any research on that. But could you not speed track the procedure rather than waiting for the lower court? Why don't it be by consent? Go immediately to the Court of Appeal and then to the CFA, because sooner or later it's bound to go to CFA. Only then, I think Beijing has the duty or the right to ask for reinterpretation. But I still think it's right and proper, and I think it's still Beijing's position that you have to exhaust the local judicial process first before an interpretation takes place. And that's provided, I believe, basically in the basic laws. So, but sooner or later, I think we know the answer already, because if China, if it goes to the Court of Final Appeal and the present law is maintained, we know, as night follows day, that Beijing will ask for interpretation, and we know the answer.
All right, thank you once again. A couple of questions. I had a question about the young offenders, but let's start with a question from the audience first. There's a question here that the police allowed people under 18 to walk free from the PolyU campus after taking down their names and ID numbers. They apparently didn't collect their mobile phones or try to obtain evidence from them for their mobile phones and so forth. Is it going to be impossible to prosecute and successfully convict them because of a lack of evidence going forward, if they should decide to do so later on?
I think it's extremely difficult in the absence of those evidence to charge or convict anyone. They have plenty of explanations and defenses possible. So unless you have some independent evidence, they'll say that I was forced to remain there, for example. How to refute that? I don't know. I mean, it depends whether there was CCTV, some confession maybe, or some other, I don't know. But it seems to me, based on what we know, extremely difficult to secure any conviction on that basis.
So unless there is evidence, as Cheng says, from cameras or whatever, recording what happened inside the campus, or unless other offenders are prepared to give evidence on behalf of the prosecution, or unless there were undercover officers in there seeing what was happening, unless there's that type of evidence, then it's certainly different.
So along those lines, once again, what's your view on how young is too young to prosecute? There's some stories about peer pressure, coercion by peers, even the giving out of drugs to young the young offenders, and clouding the judgment and so forth. Is there an age at which is too young to prosecute?
What's the issue with
Well, obviously criminal responsibility in Hong Kong is 10 years of age, isn't it? And up to the age of 17, young offenders can be given discretionary warnings, superintendent's warnings, as an alternative to prosecution. But that is normally after the victim has been consulted, and it's normally where the offence is not serious. Many of these offences, such as the bomb manufacturing which was going on at the Chinese university, involved 15-year-olds, and that type of offence would always have to be prosecuted. So you really need to look at the gravity of the offence that's been committed. And the courts and the prosecutors certainly have to disabuse people of the view that if you're young, that you can go out and commit serious crimes without there being serious consequences, because that's most certainly not the case. And as the Court of Appeal said, I think it was in 2001, that even though extreme youth may sometimes be a reason not to imprison people, the courts do, in relation to some offences, have to steel their teeth and deal harshly with even with young offenders. One of the reasons for that being, for example, in relation to drug trafficking, if the drug traffickers were able to tell young people that please do our drug trafficking for us, and even if you're caught, you only get a slap across the wrist, so you haven't really got much to lose, and we're going to give you a lot of money anyway. So to try and discourage that type of situation, the courts have made it clear where serious crimes are committed, then even young offenders must expect to be severely punished.
Thank you both. I just want to ask you a question, Grenville. You mentioned earlier that Sir Murray MacLehose was coerced in 1966 to 1977 to grant an amnesty to some of these officers accused of corruption. Aren't we facing a similar situation here in Hong Kong? Aren't we being held hostage by pretty much by violent
well, the protesters certainly are trying to hold the government hostage, and the government has already made one concession to them, and it didn't work. It simply emboldened them to make more demands of the government, and we certainly don't want to get into a situation again, as happened with Sir Murray MacLehose, where the government was compelled to let guilty people off the hook because it had been threatened. And in my view, as I said in my remarks, it's absolutely essential that these demands are, given that they are so unreasonable, be rejected out of hand, and that any further concessions to them would, far from calming things down, would actually embolden them to demand more and may actually cause yet further violence. Once people clearly understand that violence will get them nowhere, then that is something which can help to contain the situation. But if they feel that they can demand more of the government, and they've got a weak government which will simply cave into their demands, then this is a recipe for disaster going forward.
There's perhaps two differences in the particular situation. First, involve non-violent acts, in the corruption, in the amnesty, involve corruption, and obviously, unlike now, mass destructions of properties and rampant damages. Secondly, is that the particular amnesty involved police officers. They threatened to go on strike. They will break down law and order. There are two differences.
Okay, thank you. That's helpful. I'll continue with some of the audience questions, and I'll just ask them as they've been given to me. What are your thoughts on enacting legislation against hate crimes and hate speech, since much of the violence is targeted towards mainland individuals and businesses?
Well, I don't know. I mean, I suppose there's always reasons to support these particular proposed laws, but I mean, it's a matter for the society to decide whether there's a real demand for it or not. What I don't like is what, for example, the Labour government in England, the Blair government, I think they introduced some 3,786 laws, in a period of 5 years, involving crimes like hate crimes and everything. I mean, I don't know where you draw the line between a freer society or where you try to make, create more criminal offences involving perhaps not so important matters. It's a matter of opinion, I don't know.
Well, it's certainly something that can be looked at in the round, that we have to look, for example, at whether our existing laws, for example, in relation to public disorder, in relation to conduct likely to cause a breach of the peace, whether they can be deployed effectively first, or whether we actually have to go and get additional legislation. Of course, the police themselves have been pressing for a law which makes it an offence to abuse a police officer. So that is something which also be looked at. But I wouldn't have thought that there's any urgent need, because I would imagine that for most types of offences, they can be caught one way or another in the ordinary way of things.
I think this is this question touches on something that I think particularly you, Cheng, have mentioned earlier. There's and Grenville as well. I think there's a huge volume of cases that have now or should be coming before the courts. The courts are very much taxed. The prosecution department is very much taxed as well and undermanned. You both mentioned the need to hire more magistrates, more prosecutors, and so on and so forth. So within the current legislative framework, assuming that new laws will be lifted to pass in the current environment, what could the Secretary of Justice or the Chief Justice be doing? Will they, if they were minded to speed up the processing of these cases?
Well, as I said in my remarks, there were very serious delays after Occupy Central, and those definitely have to be avoided this time. The team that I mentioned, the Public Order Events team inside the Prosecution Division of the Department of Justice, it's not a large team. I think it has 5 or 6 counsel in it, answering to the DPP. And my one possible suggestion is that if they don't have counsel who can be redeployed to assist this team, as you heard, that perhaps they could retain a number of private barristers to work on these teams, both on advisory matters and also actually prosecuting them in court. That would certainly relieve some of the pressure on the Department of Justice. But there's no reason at all why the judiciary could not appoint more magistrates to help deal with the cases in the lower courts. Remember as well that riot, and many of these cases do involve riots, are one of the few cases where the magistrates can impose 5 years imprisonment. So many of these cases could actually be dealt with in the magistrates' court, and if that be right, then it would actually. Magistrates, yeah.
Magistrate in Hong Kong?
In Hong Kong, magistrate.
5 years?
5 years.
Never heard of it.
Yeah. They can. It's very strange, but they can. Yeah. Look at my book on sentencing. You've got no excuse because I gave you one.
Has anyone heard of any case of a defendant being sentenced to 5 years imprisonment in the magistrate court?
No, because it's very rarely used. We're living in different. Living in different times.
I tend to disagree with you.
So, well, that would be one way of expediting the cases, given that there are so many cases.
It may be 3 years.
It may be possible when you wanted to increase the district court jurisdiction to 12. That was to 10. Well, that would be unacceptable to the bar as well. But anyway, so we have this law there where a magistrate can impose up to 5 years, and if necessary, this is a power that could be used if the offences of riot weren't so serious that they had to go to the higher courts. But as I say, there's no reason at all why the Chief Justice couldn't appoint more magistrates, deputy magistrates if necessary. There are always a number of deputy magistrates sitting in order to help the courts get through some of the less serious crimes in the magistrates' court. Of course, this is what happened in England during the 2011 riots there. They established the so-called nighttime courts, which sat around the clock, and that helped to clear the backlog. So quite obviously, some innovative thinking is required both of the Department of Justice and of the judiciary in order to make sure these cases are processed expeditiously. As Cheng pointed out, memories do fade after a while. and the chances of witnesses recalling what happened obviously diminish over time, which makes it absolutely essential that in these type of cases, where the evidence in many times is purely identification, that these type of cases are brought on sooner rather than later.
In the Occupy Centre case, I mean, it took many years for them to find just the conviction was only last year, wasn't it? I mean, in the Occupy Centre case. Also, the other thing I want to mention is that it doesn't only affect the magistrates or the judges, it affects almost the whole spectrum of the legal system. You need more court personnel, you need more interpreters, you need more court clerks, you need more correctional services officers. So it's the whole judicial legal system. You need to increase the personnel.
So who makes these decisions to hire, additional magistrates, additional prosecutors?
My understanding is that each department would have their own say, but ultimately money. You need LawyersHK to pass the money. And we have plenty of money, but they won't spend it. We have plenty of money. Of course, very rich. But you need, I've been told that because of these riots recently, a lot of bills have not been passed. Judicial appointments have not been made because of all these delays.
I was hoping that there was a process or a procedure available that we didn't have to go through LawyersHK because it's.
I don't think so. Ultimately, it's money.
Yeah, the Department of Justice has its allocation of briefing out monies for any particular year. And obviously it would have to brief this team of barristers that I've suggested out of its briefing out vote. And that would mean, of course, there would be enough money to brief barristers to do cases in the more generalised crime cases. But of course, we're seeing both in the Department of Justice and in the police force that the regular criminal cases are being pushed onto the background because everyone is being preoccupied with the protest cases. So justice is being delayed across the board in relation to other types of crime as well.
Just look at the daily cause list. Daily cause list, acting magistrates, acting district court judges, acting high court judges, and the reason is because they say there's not enough money to pay for full-time judges.
So in terms of processing this is a slightly different question, processing the arrest of offenders, you mentioned earlier that the arresting procedure is very lengthy, it takes a lot of time, it's a lot of work just to arrest someone. Is there any way within the current legislative framework to speed that up without going through LawyersHK?
I think tendency is to create more work rather than lessen them. For example, I've been told in England nowadays, an average police officer is quite reluctant to arrest anyone for petty crimes because there's so much workload involved, papers to sign and fill, so they prefer not to arrest unless very serious offences are involved. And this become a tendency in Hong Kong. For very petty crimes, hardly worth it almost.
We have a question here about jury trial. The question is, how can we ensure in a jury trial that the jury's verdict is not affected by their political affiliations? Is there anything in the rules that
Nothing so far unless you follow the American system and vet them a bit. You have to vet the political view. Even then, of course, they always lie. The nearest is the vetting procedure under the American system. When they ask for political views, where you believe white is white, black is black, that kind of stuff.
And do we have this?
No, not in Hong Kong. No. And very unlikely too.
Another question we have is, after 22 years, Article 23 of the Basic Law has still not been implemented in the HKSAR. What can the central government do to protect national security in Hong Kong? And I guess, is there anything that can be introduced into Hong Kong under Annex 3 of the Basic Law in that regard?
Well, of course, the mainland can extend mainland laws to Hong Kong by placing them in Annex 3. They've been extremely restrained so far, even though they have indicated from time to time that they really expect Hong Kong to discharge its responsibilities. But I would have thought that the longer nothing is done here in Hong Kong, the greater the chances of that happening are increasing. As I mentioned, Macau implemented its laws within 10 years, and Hong Kong has done nothing. And the problem, of course, is that we have a dysfunctional legislature. If the Article 23 legislation were to be brought back again, not only would the opposition members try to filibuster, there may be violence all over again. And obviously this is a potent consideration. And likewise, in like vein, I wonder what's going to happen about the national anthem law. I mean, that was adjourned last summer for consideration in this session. It's meant to be proceeding through the Legislative Council, and we've heard nothing about it. So I don't know if the view is being taken that it's too dangerous to bring it back, or whether the view is that there will be violence if they bring it back. But again, this is something that Hong Kong is required to implement, and the real concern is that the legislature is no longer able to deliver on laws, and in light of that, it seems to be there's an increasing possibility that the mainland will take action itself and make amendments under 160 of the basic law.
It would probably take a very brave legislator to table the national anthem law. You know,
it's been through its first stages. Yeah.
It
was adjourned last summer on the understanding it was going to come back in October or November. So, I mean, it's a government bill which is there before the legislature, waiting for the processing to continue. So unless the government is going to pull the rug on that as well, then it'll have to come back by the summer.
Given Carrie Lam's experience with the extradition bill, I think it's one shudders to think what would happen when they.
Well, you just wonder how many times the central authorities are going to allow her to drop bills without themselves taking action, extending them to Hong Kong.
So on that subject of Carrie Lam, what's your view on Carrie Lam's proposal to have an independent review committee instead of a commission of inquiry? I'm not sure if you've heard of this. I haven't really studied it myself.
Review what? Review about her administration.
That aside, since it's not something we've heard much of, let's move on to the next question. Okay. So this is a hot button topic for a lot of us in the legal profession. The Hong Kong Bar Association has released a number of public statements, which are, in many people's view, are biased. As legal practitioners who do not agree to their stance, what should we do before the next election of the Bar Council?
Try to change the bar committee members if you can. But I think more seriously, I think that I've said about this, and I'm not afraid of saying it. The bar council has been hijacked by a number of pro-democratic people who have a vested political agenda. I've always maintained that. I'm always against that because I believe very much in the independence of the bar and the law society. We are essentially trade unions. We try to protect the interests of our members and not, if possible, to dwell too much into the political arena. I've said that in the past it might be so because in pre-colonial, in the colonial days, be it in Malaysia, Singapore, or Myanmar, the colonial government always encouraged a very strong bar because that took the place of an opposition party. And you see that in the old days, all the senior members of the bar became ex-co member or hold some position in the administration of the government. But those days are gone. I always tell members of the bar, if you're interested in politics, go and join a political party, go and stand for election, and make your voice known in LegCo. But don't use the bar as a political vehicle. I have very strong views about that. Thank you.
Thank you very much. I think we've really taken out a lot of your valuable time, and we've really learned a lot from hearing you speak, the both of you today. So thank you very much. As a token.